And good afternoon, Facebook. Welcome to today's delayed due to technical difficulties Ask a Lawyer live on Facebook Live. I'm attorney Michael Bender.
And I'm attorney Tilton, and we are the Gray Legal Group.
The information in this video is for informational purposes only. Nothing should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt or viewing does not constitute an attorney-client relationship. Here today to answer two questions, one with regards to protecting your rights in a divorce, and the second is with regards to step-parent adoptions. So Alice is going to take the first one here. How do I know my rights in my amicable divorce will be taken care of if we use my wife's attorney for the whole process? I'm divorcing my wife and have decided to get it taken care of ASAP. We want a clean break, and she says she wants nothing from me. How do I know my rights will be protected if her attorney drafts all the court documents? Allison?
This is a, thank you, Michael. This is something common that comes up quite frequently where the parties decide that they want to just use one attorney for the divorce process because they just feel like they're going to agree on everything and it's just not going to be an issue. The problem with having one attorney draft everything is that the attorney is going to be drafting all the documents, or at least representing the party that's hired that attorney. It's our job to represent our client's best interests, and the attorney, in this case the wife's attorney, would be representing the wife in this case. That's a little different from when you go to an attorney for mediation services, which is not, in a mediation service, the mediator's not representing anybody's interests. The mediator's there to try to help the parties resolve the issue. But in this case, if it's the wife's attorney, then the wife's attorney is looking out for wife. If she or he drafts all the documents, you have the right to take them to your own attorney, an independent attorney, to review all those documents. I would strongly suggest before you sign any agreements, you do have an attorney review everything, because that attorney could explain to you what those documents say, explain to you what your rights are relative to the divorce, and how you're protected or not protected under those documents.
If I could just add one thing, basically from the wife's perspective here, I would not only, I would definitely encourage the other party. No, from the wife's. Encourage the husband to take them, because if, let's say, less than 6 months down the line, husband goes to an attorney, finds out that everything is all their rights were taken away, there's a high likelihood there that husband could file for a set-aside and you're back at square one. However, if the husband had gone to an attorney at that time to take a look at it and was fully aware of what they were signing, then a set-aside would be less, I would say, less likely. So if I were a wife, I would encourage husband to go get it looked at independently.
Sounds good. That sounds good. I'll give you that one.
Thank you.
Okay, this question is for Michael. Can my husband adopt my son if I'm receiving child support from the other parent? Oh, I'm sorry. I seem to have trouble reading these questions. Can my husband adopt my son if I'm receiving child support, but the other parent hasn't been involved for over 3 years? My husband and I have been married for 2 years, and he has been in my son's life for 3. My son's father has not seen him or been involved in his life for over 3 years. He just recently started paying child support through the Department of Child Support Services. Can my husband adopt my son?
Well, what we've got here is basically it's a request for a step-parent adoption. And the way a step-parent adoption works is a two-part process. First thing that needs to be done is the termination of the biological parent's parental rights. And the second step is actually having the step-parent step in and becoming the legally recognized father of the child. In order to terminate parental rights, based on this, I would say that there's a high likelihood that that it would be granted. In that, what you need to show is essentially the one way to do it is the abandonment of a child. And if there hasn't been any involvement, any contact or anything by the biological parent in over a year, then the court can determine that that the biological parent abandoned them and the rights would be terminated. As far as just started recently paying through DCSS, Department of Child Support Services, if child support is one of the factors that are looked into, if there was an affirmative action taken by the mother to go ahead and try and collect child support, the court may waiver on that. But if it's directly through Department of Child Support Services, it could be an aid situation where mom had no participation in that at all. So I really don't think child support is going to be a key factor here. I think the court would just look at, has there been an abandonment? Basically, the biological father's been out of the picture for over 3 years. And so long as you and your husband have been married for over a year, I think that step 2, the court's going to look at what's in the best interest of the child. Sees as somebody who's there and wants to be involved, wants to parent this child, step in the father's role. It would definitely be, well, I can't say definitely, but would be looked favorably. So,
Favorably.
Anything to add to that?
No, I think that about that covers a really quick view of step-parent adoptions.
Very quick. Well, thanks for joining us today on Ask a Lawyer. Join us each week as we discuss the family law issues important to our community. If you have a legal question or topic you'd like us to address, go to thegraylegalgroup.com and click on Ask a Lawyer. We'll see you next week.